request the leader would make for this committee to continue to work while the Senate is in session.
Well, let me be sure I understand. Senator Schumer is saying that we have to shut down while the Senate is in session. Do we not generally waive that rule?
Yeah, generally it is waived, but if it's objected to, we can't meet. So that means that we want to make sure that we get the executive or the closed session out of the way.
Well, may I ask why Senator Schumer is doing that?
Has he done it?
I don't know.
We have a nominee to the Supreme Court of the United States. We've all talked about transparency. What is his basis for doing that?
You'll have to ask him. I don't know.
Mr. If I may, I would just like to put a document in the record that the committee was told that President Trump has decided to withhold 102 pages of Kavanaugh's White House counsel records. 102,000. What did I say?
102. You're close.
Thank you. 102,000 pages of Kavanaugh's White House counsel records, and asserted a new claim of constitutional privilege, and of course that hasn't been done before. I'm told there's no such privilege. There's an executive privilege, which is outlined in the Presidential Records Act and requires the president to notify Congress and the archivist, which was not done here. There's a little bit more to it, but I'd just like to put this in the record.
Without objection,
Thank
that
you.
will be put in the record. Yeah. Judge Kavanaugh, we've heard a lot yesterday about your record of independence and impartiality, and you've done more than talk about your independence and impartiality. You've demonstrated the judicial values of the bench. By my account, you ruled against executive branch agencies 23 times between May 2006, January 2009. Of course, President Bush who nominated you to the bench, was the head of the executive branch. You had no problems ruling against the president who appointed you, if that's what the law required. And I have no doubt that you'd do the same on the Supreme Court if that's what the law required. You've demonstrated your impartiality. Some of my colleagues tried to depict you as hostile to the little guy and always willing to rule for the powerful, but your record shows that you rule for the party that has the law on their side. So that makes you out to be not a pro-plaintiff judge or pro-defendant judge, but to be a pro-law judge. So let me ask you about a few of your cases that I think demonstrate that you will vindicate the rights of those who are less powerful in our society. After all, our aspirations as Americans is equal justice under the law. So, I'll ask you to on each one of them, but just so you know, the three cases I'm thinking about is Rosello, Essex Insurance, and United Food and Commercial Workers. So in the first one, the case in which you ruled for the women wrongfully denied Social Security benefits, tell us your approach to that case.
This case, Mr. Chairman, was a case in which the Social Security Administration had denied benefits. It was a case where the Social Security Administration had denied benefits to a woman who had a history of mental illness, and they had done so because at one point in time she had been employed for a brief period of time with a family member, but it had been subsidized. And this was, in my view, the height of arbitrary agency decision-making. The case had gone on for 15 years, was kind of a hall of mirrors for the woman, and I wrote an opinion reversing the denial of benefits for the woman and also making clear to the Social Security Administration that any further delay would not be tolerated, and that these kinds of delays in denying benefits to people with mental illness were unacceptable.
Let's go to the Essex Insurance Company case. Right. Essex Insurance.
In the Essex case, it was a case of a child's family and an insurance company, and the child had been the victim of sexual abuse, and on 3 occasions, and the insurance company was trying to pay out simply $100,000 for the total number of for the abuse, and the insurance policy said $100,000 for each occurrence, in essence. And we ruled that the insurance company had to pay $100,000 for each occurrence, each incident of the abuse, and therefore a total of $300,000. So in that case, we were ruled, and I wrote for a victim of abuse against an insurance company that was seeking to squeeze the benefits that were paid under a policy that was owed to the plaintiff in the case.
Okay, then the last one would be United Food and Commercial Workers.
And that's a case, a union case against Walmart, and the case came from the NLRB, and the question was whether Walmart had engaged in unfair labor practices against a union in that case. And in that case, we ruled for the union against Walmart in that case on the ground that the factual record supported the conclusion that the company had engaged in unfair labor practices and therefore violated the rights of the union members.
Yeah. Now to something that I believe I've discussed with every nominee to the Supreme Court probably for the last 15 years. It's not about a case or your approach to the law, and it's something that Senator Kennedy talked to you about yesterday. It isn't a very popular subject with some of the current and former justices. I think I make Chief Justice Roberts uncomfortable when I raise the issue with him when I speak for a short period of time at the Judicial Conference. And then there was a former, when Justice Souter was on the Supreme Court, he made a famous quip about television cameras that they'd have to roll over his dead body. I can respect that view. I just think it's plain wrong. I and many of my colleagues on this committee believe that allowing cameras in the federal courthouse would open the courts to the public and bring about a better understanding of the court and its work. You may be aware of that for a number of years I've sponsored a bill, the Sunshine in the Courtroom Act, which gives judges the discretion to allow media coverage of federal court proceedings. Would you keep an open mind on cameras in the courtroom, or if you have strongly held views on it, don't be afraid to tell me.
Mr. Chairman, I appreciate your longstanding interest in the issue and transparency for the courts, of course. And I'll tell you what we've done on my court briefly, and then tell you some general thoughts going forward if I were to be confirmed. On our court, we've gone from audio release at some date much later. Then we went to audio release same week. Then we went to audio release same day. And now we are allowing audio to go out live with the oral arguments. And that process has been one in which the judges have learned, experienced, and become comfortable with the additional transparency that's become in the same time audio over time. And that process has worked well in our court. On the Supreme Court, I think the best approach for me is to listen to the views of people like yourself, Mr. Chairman, and others I know who are interested in that, to learn, if I were to be confirmed, from the experience there and to see what the experience there is like, to listen to the justices currently on the Supreme Court, as I've said, be part of a team of 9. Well, I'd want to learn from the other justices what they think about this, because several of them, as you know well, Mr. Chairman, when they are in my seat, expressed support for the idea of cameras for oral arguments, and then when they were there for a few years, switched their position after experiencing it. So I'd want to talk to them why that position. And as I said to Senator Kennedy last night, too, I'd want to think about the difference between oral argument and the actual announcements of the decisions. I think those are two distinct things. There hasn't been much focus on the possibility of live audio, for example, of the decision announcements or video of the decision announcements. And I think that's a distinct issue from oral arguments. And I'd be interested in thinking about that and talking to my colleagues if I were to be confirmed. I will have an open mind on it. And I do think when you attend oral argument at the Supreme Court, as I have many times, or you attend the announcement of decisions, it is extraordinarily impressive to walk into that building and the majesty of that building. The building itself conveys the stability and majesty of the law, and to go into the courtroom and to see the justices working together as they do to try to resolve cases is extraordinarily impressive. It makes you confident, I believe, in the impartial rule of law and in each member of the Supreme Court to see them in action. And so I do understand your point of view on this, and I would certainly keep an open mind on it and listen to you and listen to the other justices on the court, of course.
Thank you, Mr. Chairman. I'm going to go back to Roe because most of us look at you as the deciding vote. And I asked yesterday if your views on Roe have changed since you were in the White House. You said something to the effect that you didn't know what I meant. And we have an email that was previously marked confidential but is now public, and shows that you asked about making edits to an op-ed that read the following, and I quote, "First of all, it is widely understood, accepted by legal scholars across the board, that Roe v. Wade and its progeny are the settled law of the land," end quote. You responded by saying, and I quote, "I'm not sure that all legal scholars refer to Roe as a settled law of the land at the Supreme Court level, since court can always overrule its precedent, and 3 current justices on the..."
Roe v. Wade is an important precedent of the Supreme Court. It's been reaffirmed many times. It was reaffirmed in Planned Parenthood versus Casey in 1992 when the court specifically considered whether to reaffirm it or whether to overturn it. In that case, in great detail, the 3-justice opinion of Justice Kennedy, Justice Souter, and Justice O'Connor went through all the factors, the stare decisis factors, analyzed those, and decided to reaffirm Roe. That makes Casey precedent on precedent. It's been relied on. Casey itself has been cited as authority in subsequent cases such as Glucksberg and other cases. So that precedent on precedent is quite important as you think about stare decisis in this context. A similar analogy, the United States versus Dickerson case in 2000, where the court considered whether to overturn Miranda versus Arizona. The court, through Chief Justice Rehnquist, specifically reaffirmed Miranda, despite the fact that Chief Justice Rehnquist had been a critic of Miranda in his early days and had written some opinions quite critical of it. It became that, so that Dickerson case is similarly precedent on precedent, which is important going forward as you think about the stare decisis calculation for a case like Miranda. So that's why both of those cases, Planned Parenthood versus Casey and Dickerson, are cases where I would refer to them as precedent on precedent.
So you believe it's correctly settled, but is it correct law in your view?
Senator, there's on that case or on Dickerson or on cases like Citizens United or Heller or United States versus Lopez or Kelo, just the whole body of modern Supreme Court case law, I have to follow what the nominees who've been in this seat before have done.
Judge, a yes or a no will do.
Well, I'm just, if I can briefly explain.
Yes, you can.
Briefly, I'll try to be brief, but when you're in this seat, I'm not just sitting here for myself. I'm sitting here as a representative of the judiciary and the obligation to preserve the independence of the judiciary, which I know you care deeply about. And so